यहाँ पर संविधान की अच्छाइयां गिनाने नहीं जाऊंगा, क्योंकि मुझे लगता है कि संविधान कितना भी अच्छा क्यों ना हो, वो अंततः बुरा साबित होगा अगर उसे इस्तेमाल में लाने वाले लोग बुरे होंगे, और संविधान कितना भी बुरा क्यों ना हो, वो अंततः अच्छा साबित होगा अगर उसे इस्तेमाल में लाने वाले लोग अच्छे होंगे।
What you just heard was the speech given by Dr. Babasaheb Ambedkar during his Constituent Assembly speech on 25th November 1949. In my last video, we spoke about PMLA, FERA, money laundering, etc. But in today's video, we'll speak about one of the recent judgments passed by the Supreme Court in the case of Mr. Vijay Madanlal Chaudhary versus the Union of India, passed on 27 July 2022. A bench comprising Justice A.M. Khanvilkar, Dinesh Maheshwari and C.T. Rajiv Kumar produced the judgment in more than 200 pages. The judgment became quite controversial. I believe that the judgment was quite comprehensive and it covered all the aspects in a detailed length and breadth. However, I believe one aspect which referred to the law related to interpretation of treaty and visa via Constitution of India has been missed out. So we'll talk about the three major issues raised by the petitioner in the court. Number 1. Copy of ECIR is not being shared to the accused, and so the accused is not aware of the charges framed against him or her and for what reason he or she has been arrested. This was one of the most controversial issues, which according to the petitioner violates the Article 14 and 21 of the Constitution, which are fundamental rights of principle of natural justice. The Honorable Court replied to this by saying any of these articles were not violated because the principles of natural justice can be invoked only after the arrest and not before that. Number 2. Statements given by the accused to the ED officers are admissible in the court of law as an evidence. This is self-incriminating, means I am giving a statement against myself which violates Article 20 Section 3 of the Constitution, which says that no person accused of any offence shall be compelled to be a witness against himself. Like any statement given by accused to the police is not admissible in the court of law. So here, the court has taken a view that the ED officers cannot be equated to the police or CRPC does not apply. Number 3. Twin bail conditions for taking a bail. In PMLA, the maximum term of punishment is 7 years, indicating the offence is not a grave. But the standard for securing bail is extremely high, with a twin condition. Example A. The accused has to prove that he is innocent, and B. The court needs to satisfy that the accused will not do such crime in the future, which is based on the purposive interpretation of the PMLA. To satisfy condition A, the accused has to go through a long period of trials, which obviously takes a lot of time. Honorable Court has taken a view in the judgment where there is a breach in various fundamental rights of a person under the Constitution. It is stated that India and its versions of PMLA is merely a cog in the international vehicle, and as India is a signatory to the treaties signed in the UN, therefore is bound legally and morally to adopt the best practices and respond to the changing needs of the time. If we look at the directive principles of Article 15 Section C of the Indian Constitution, which states that state should endeavour to foster respect for international law and treaty obligations in the dealings of organized peoples with one another. As I said, Article 51 falls under the directive principles, and from Article 14 to 21 of Principles of Natural Justice fall under the fundamental right. Fundamental rights are justiciable as they can be enforced by the court legally if there is any sort of breach or violation. But at the same time, directive principles are not justiciable as they cannot be enforced by the court if there are any violations. In a nutshell, fundamental rights should prevail over directive principles. However, in the present ruling, it seems that the Honorable Court has thrusted more on directive principles as opposed to fundamental rights. It should be noted that as per Article 245, subject to the provisions of this Constitution, Parliament may make laws for the whole or any part of the territory of India, and legislator of a state may make laws for a whole or any part of the state. From the analysis of Article 245, we see that any law accordance to the Constitution of India can be enacted in India by the Parliament. meaning laws formulated should adhere to the principles of the Constitution and not oppose them. I believe that the soul of this judgment is based on the international treaty signed by India for the PMLA. Under the guise of the treaty, the Honorable Court has tried to justify some draconian provisions and some which are also contrasting with the Constitution of India. As I'm making this episode, the Congress MP Kartik Chidambaram has already filed a review petition challenging PMLA judgment with a larger bench of Supreme Court, and his review petition has been accepted by the Supreme Court. If you like the video, please consider subscribing. For more videos like this, please stay tuned. Thank you.